Upon further review, this court will in fact enter an order sending Mr. Adams and Steele's, Mr. Weinstein, and Mr. Banks' motion to recuse to another judge pursuant to Uniform Superior Court Rules 25.1 through 25.7.
I'm gonna be honest, boys, I'm getting a little nervous about this whole transcript situation. The Young Thug YSL RICO trial is on hold until another judge rules on the motions to recuse Judge Glanville. The judge now plans to release the unredacted transcript of the ex parte meeting and claims everything was proper. He says the subject matter of the ex parte meeting was an emergency meeting to explain to Woody his immunity deal, and not anything regarding what Woody would testify to. So the judge has his back against the wall now, and he's claiming everything was proper even though they never notified the defense of this ex parte meeting? I don't know how that would be proper, but he cited a bunch of case law that basically explains why the defense didn't need to be in there, and that it wasn't a critical junction of the trial. Basically, the judge is saving his ass for the entirety of this video. I'm a little concerned that whatever judge reviews this is not going to recuse Judge Glanville because he's going to somehow think it's proper based on the transcript. Hit subscribe, like the video, here we go. First look at Thug on day 100. Bobbing his head to some music. It's blurry though. Something's happening. It took 2 hours for court to start.
As you all are made aware, last week the court was going to do an in-camera review of the ex parte proceedings on June the 10th of 2024. The court has decided to release the entirety of the transcript of those proceedings.
So he's going to release everything. Not redacted, I would imagine.
On Friday, June the 7th, 2024, Mr. Kenneth Copeland was granted immunity from prosecution. Mr. Copeland, who was represented by Mr. Donovan and advised of his rights and obligations. During the proceedings on Friday, June the 7th, Mr. Copeland invoked his Fifth Amendment privilege and was held in contempt. Mr. Melnick informed the court that he was not going to be in attendance of any further proceedings as he would be on leave effective 10 June of 2024. Mr. Melnick relayed that attorney Caleb Bumpus would be representing Mr. Copeland. On Monday, June the 10th, before court, Mr. Edward Chamberlain, the court's litigation manager, informed the court that the state wished to have an ex parte meeting with the court.
Here we go. Let's see if he explains anything that happened in this ex parte meeting. Woody admitted that he killed Donovan Thomas Jr. Exculpatory Brady evidence for the defense they didn't give over. And the judge basically threatened him years in jail if he didn't testify because he would be held in contempt for that long until all the other trials.
No subject matter of the ex parte meeting was told. The entirety of the ex parte hearing held on the 10th of June of 2024 was taken down by Ms. Christina Weaver, the court's official court reporter. This ex parte hearing was held in chambers starting at 9:10 a.m. Present along with the court were Ms. Caleb Bumpus, attorney or ADA Ms. Adrian Love. The ex parte hearing stood in recess 9:34 to 10:03 a.m. to await Mr. Copeland's arrival. The ex parte hearing resumed with Mr. Copeland present at 10:03 a.m. Also present were attorney Bumpus, Ms. Hilton. The ex parte hearing stood in recess to allow Mr. Copeland to have a private conversation with attorney Bumpus from 10:17 a.m. to 11:28 a.m. The ex parte hearing resumed at 11:28 a.m. The ex parte hearing concluded at 11:31 a.m. Returned from lunch, and Mr. Steele informed the court that he had a motion, and that was at 1:46 p.m. In asking then Mr. Steele later that afternoon was held in contempt. However, he was allowed to continue representation of Mr. Williams. The court, in asking Mr. Steele questions of how he received the information that he proffered in open court, was only concerned about the integrity and security of the conversations that were had in chambers, not whether those conversations were the subject of proper ex parte conversations or the sum and substance of what was told to him at that time.
The judge really trying to die on that hill. One of the defense lawyers should have been in this ex parte meeting. That's what the defense lawyers were upset about.
Jurors entered the courtroom to resume Mr. Copeland's testimony at 3:39 p.m. The jurors were excused and exited the courtroom at 5:56 p.m. Mr. Copeland was excused and exited the courtroom at 5:58 p.m. The court asked Mr. Steele again whether he received ex parte information, and that would be at 5:59 p.m. Mr. Steele's counsel, Ms. Ashley Merchler, entered the courtroom. Mr. Steele was held in criminal contempt, and the proceedings concluded at 7:41 p.m. The court further takes judicial notice of the following statements proffered by Attorney Steele, Brian Steele, in open court upon information and belief stated to the court, which are still unknown. There are 6 assertions that Mr. Steele proffered in front of the court. The first assertion,
He loves that word assertion.
and the transcript bears out exactly what Mr. Steele said, so the court is paraphrasing, involves his concern that supposedly in chambers, this honorable court reporter, court at times, district attorney or district attorneys before the DA's office, as well as investigators, sheriff, and deputies, Mr. Copeland and his counsel met together. None of the defense team, to his knowledge, were present.
How's he going to defend this? Let's see. He's about to state a bunch of case law or some bullshit, dude.
Second assertion he makes is that Mr. Copeland intended to plead the Fifth Amendment. Third assertion is that Mr. Copeland, as a party,
Thug is asleep.
was sworn, and Mr. Steele asserted that this particular conversation was, in fact, a critical stage, and that the defendants had the right to be present. The fifth group of assertions involved Mr. Copeland not going to testify. The fifth group of assertions involved what Ms. Attorney Hilton claimed or said to the witness, to include the court, involving allegations of coercion and witness intimidation, and that his counsel had the right to be present. And the sixth assertion that was made in open court was that Mr. Copeland admitted to killing Donovan Thomas. At some point after Mr. Steele was held in contempt by this court in the afternoon of June the 10th, it was brought to the court's attention, not at the court's request, by security personnel that video footage of what occurred outside courtroom 1C shows the interactions between Ms. Bumpus, Mr. Steele, Mr. Adams, and Mr. Sharp.
Oh, so now he's throwing Miss Bumpus under the bus for leaking it to the defense lawyers. Because Miss Bumpus was Woody's lawyer at the time. She was the leak to the defense lawyers. That's what he's hinting at.
Court in no way sought to investigate any facts of this involving this footage, and it only considered it for the security and timeline of events that occurred on June the 10th of 2024. Also, in no way did the court consider any of this footage in holding Mr. Steele in contempt. And as I said, mentioned it only for the purposes of considering the security and breach of information that occurred within the court's chambers, not for the whether or not that was truthful or not. Mr. Steele makes further made three assertions on the 10th of June of 2024. One, he asserted that this was, on behalf of Mr. Williams and similar situated individuals, that this was, the court held an improper ex parte meeting. Secondly, that Mr. Copeland was a sworn witness, and this was a critical stage. No, Mr. Copeland was a sworn witness, and third, that he argued that this was a critical stage and that he and the others needed to be present at that point in time to pursue the Sixth Amendment rights of the defendants in this case. As to Mr. Steele's first assertion of whether or not the court held an improper ex parte meeting or hearing, the court is guided by Judicial Code of Conduct 2.9, which I'll take judicial notice of. In pertinent part, where circumstances require ex parte communications are authorized for scheduling, administrative purposes, or emergencies that do not deal with the substantive matters or issues, provided that the judge reasonably believes that no party will gain any procedural, substantive, or tactical advantage as a result of the ex parte communication, and the judge makes provisions promptly to notify all parties of the substance of the ex parte communication and gives the parties an opportunity to respond. In this particular circumstance, the transcript of these proceedings was just prepared and is final by my official court reporter, Ms. Weaver, and all counsel will be, as I said, given an opportunity to, as soon as the court finishes entering this order, it will be e-filed, so everyone will have a chance to take a look at it and use it as they see fit. If a judge inadvertently receives unauthorized ex parte communication bearing upon the substance of the matter, the judge shall make provision promptly to notify all parties of the substance of the communication, provide the parties with a reasonable opportunity to respond. And as I mentioned earlier, I'm going to release the entirety of the transcript to you all to use as you see fit before any other further examination of Mr. Copeland. I'll address the issue of the emergency nature of this particular hearing.
So I think he realized he fucked up saying he was going to redact part of the transcript, because that was ludicrous.
Is that this involves the state's concern as to what Mr. Copeland was in fact told by his counsel, Mr. Melnick, and his understanding of the immunity agreement. The conversations that were had in the transcript will bear out that no tactical or other advantage or any testimony that was stated during that particular hearing would be anything other than the court and or the state communicating, along with Ms. Bumpus, his lawyer, who was there the entire time, his witness's understanding of his immunity agreement. In consideration of this emergency nature, the court has taken into account a couple of cases I'll cite for the record. The United States versus Adams.
Oh wait, he's citing cases to defend himself. Here we go.
Although an ex parte conference to discuss threats against the witness is proper, the district court must ensure that the conference is carefully conducted so no rights of the defendant are threatened. Ex parte conference between judge, prosecutor, and government witness to discuss refusal of witness to testify because of his fear of reprisal was not improper, where substance of the inculpatory testimony was never discussed and the entire conference was transcribed.
So he's citing a case where the actual subject of what he's going to testify about wasn't the issue, it was whether or not he was scared to testify.
Adams, the appellants contend that the ex parte conference was improper and it violated their due process right to a fundamentally fair trial. We agree with appellants that ex parte conferences should occur, but rarely, especially in criminal cases. This does not mean, however, that such conferences are unconstitutional. Indeed, some situations the trial judge may find an ex parte conference necessary. In the exercise of the court's residual power to ensure a just trial, protect jurors and witnesses, a judge may, in rare circumstances, feel it necessary to confer with a juror or witness on the record, but outside the presence of others, including the defendant. One such conference may be where a juror or witness, having been threatened, wish to speak with a judge privately about a threat. A witness may not feel free to discuss any threats in presence of the defendant or even counsel for the defendant. We agree that the First Circuit, that an ex parte conference is appropriate in that situation. Exclusion of certain defendants and counsel from in-camera proceedings permissible in multiple defendant trial, where certain defendants had cooperated with government and received death threats. Although an ex parte conference discussed threats against witnesses proper, the district court must ensure that the conference is carefully conducted so no rights of the defendant are threatened. In this case, the court followed procedures to ensure the conference was fair. First, at no time was the substance of Pooley's inculpatory testimony discussed. And second, the entire conference was transcribed. And that's United States versus Watchmaker. First, when the prosecutor began to impress upon the witness the distinction between being paid for testimony and afforded protection, the trial court should have called the conference to a close. The portion of the record quoted above indicates an attempt by the prosecutor to coach the witness on how to answer questions about inducements from his testimony. The court had already learned all it needed concerning the witness's fears and the prosecutor's plans for protection, there being no reason to participate in such coaching. Second problem occurred where Pooley took the stand. Defense counsel inquired about what inducements had been given for Pooley's testimony. Only promise was the prosecutor would seek to enroll Pooley in witness protection program if he were in fear of his life. Neither related to the prosecutor's pledge to seek immediate protection for Pooley should it be necessary. The exchange occurred before the court, and the court should have made sure that the inducements made as in the ex parte conference were completely and precisely disclosed.
You didn't disclose it. You just cited a case where they should have disclosed it. They never disclosed anything to the defense. They were completely in the dark for hours waiting for the trial to start.
Similarly, in this matter, the only thing discussed between the state counsel for Mr. Copeland and this court were the understanding of his immunity agreement. There were no other testimonial statements made by in terms of what Mr. Copeland planned to testify to.
Someone's lying then. Did he ever admit to killing Donovan Thomas? That's what he would testify to. Bro, are they about to release a transcript that's like not right? I'm gonna be super freaked out if this transcript doesn't have that in it, because then that means someone's lying or someone's fucking corrupt and changed the transcript.
Bruner versus the state, what is defined as a critical stage and under the Sixth Amendment. Bruner contends that he was denied the right under the Georgia Constitution to be present at certain critical stages of his trial proceedings. Embodied within the constitutional right of the courts to a criminal defendant's right to be present, see, and hear all the proceedings which were had against him on trial before the court. The right to be present attaches to any stage of a criminal proceeding that is critical to its outcome if the defendant's presence would contribute to the fairness of the procedure, and that's Huff versus the state. Thus, a critical stage of a criminal proceeding is defined as one in which the defendant's rights may be lost, defense is waived, privileges claimed or waived, or one in which the outcome of the case is substantially affected in some other way. And in this particular case, the court is of the opinion based on the case law that.
So he's basically saying it wasn't an important ex parte meeting for it to qualify as a critical stage, but who knows, man? I wonder how the defense lawyer is going to react to this.
That this was a proper ex parte meeting.
How was it? You didn't tell the defense it occurred. I thought ex parte meetings you had to disclose it to the defense immediately. This is 3 weeks later.
Rule 2.9, as well as the no party gained any tactical advantage, and that Tarleton versus the state, and that involves a Sixth Amendment critical stage definition that was decided June the 21st of 2023. Criminal defendant's right to be present under the Georgia Constitution attaches to any stage of the criminal proceeding which is critical to its outcome if the defendant's presence would contribute to the fairness of the procedure, but the right does not extend to situations where defendant's presence would be useless or benefit but shadow. Under the Georgia Constitution, defendant who is represented by counsel need not be present for portions of the trial that involve questions of law inconsistent, but the right does not extend to situations where the defendant's presence would be useless or benefit or shadow.
I'm gonna be honest, boys. I'm getting a little nervous about this whole transcript situation.
The court takes no position on whether Attorney Bumpus violated the duty of candor to other counsels involved in this case. These two questions can be resolved by the State Bar of Georgia and or our Supreme Court. The court further takes no position on whether Mr. Steele, his use of the June 10th proffered information as his use on behalf of Mr. Williams falls within our guidelines as set forth in the Georgia Rules of Professional Conduct. As a result of this transcript release, the court withdraws the show cause for your client and others who may be present who are present in chambers on the 10th of June of 2024. Upon further review, this court will in fact enter an order sending Mr. Adams and Steele's, Mr. Weinstein, and Mr. Banks' motion to recuse to another judge pursuant to Uniform Superior Court Rules 25.1 through 25.7 in the method and manner prescribed by our local rules. So this written order is entered.
I mean, he had no choice to do this. His back's against the wall and he's acting like it was all proper now. But I'm a little scared that this judge is going to read this transcript and not find anything wrong with it, and he won't recuse Judge Glanville.
And until such time as those two things are decided, then we'll be in recess until that time. Ms. Novi, can I ask you a question before you start anything? Didn't your law firm represent one of the co-accused in this case? How are you then? Do you have an actual or perceived conflict in this case? Could you state for the record how it is that you don't think you have a conflict? Because you did represent one of the co-accused in this case, correct?
Your Honor, this has absolutely nothing to do with my representation of Sergio Kitchens. Haven't even discussed it or come up, and what happened in the ex parte proceeding. Completely different matter, and now we're dealing with a contempt hearing of Ms. Bumpus as opposed to a criminal prosecution of Mr. Kitchens. Completely different, and in fact, everything that we've gone through or anything we've learned about this case has nothing to do with what we've done with Attorney Bumpus.
Okay, I just want to, because you may have an actual or perceived conflict, I just wanted to bring that to your attention. So if you think that it should be addressed, then I'm giving you the opportunity to do so at this point in time.
Your Honor, do we have a timeline of when the motion
That's what I wanted to know. How long will this shit take?
may be heard?
Don't know. That has to go to another judge pursuant to our local rules. So it will be basically put on the wheel. Of course, I don't have anything to do with that. So as soon as our clerk, Madam Clerk, Ms. Alexander, and her team spin that.
Is this something that we can expedite? I mean, the state does have very concerns that we hold the jurors indefinitely regarding this matter. Is there anything that could be expedited so that those decisions can be made on a motion of recuse and we can move forward with the trial?
While I understand your concern, I think the rules are transfer and recusal are pretty clear. That I'm not going to comment on anything that is pending at that point in time. Hopefully it will get done fairly quickly in terms of somebody acting on it. Okay. Then we're in recess and we'll see you in a little bit. Okay.
I'm gonna be honest, boys. I'm a little concerned that this trial is gonna continue. I'm getting the vibe that the judge is covering his ass, and that the other judge that's gonna review this is gonna find no wrongdoing in the transcript, and it's just gonna continue. He was acting like this was all proper. They never even notified the defense this occurred. Sounds like he's claiming some emergency, but that's not what this was about. And even so, he gave no notice to the parties. Yeah, his idea of emergency was state needing to explain to Woody what his immunity deal actually was. I don't buy it, but I don't know the law on what constitutes an emergency. Even so, like you said, no notice was given as required by the rules anyway. I'm still concerned that somehow this judge may have found a loophole giving all of this to them 3 weeks later. And so it doesn't seem to apply here. Woody hasn't shown an ounce of fear for his own safety. It's the exact opposite, in fact. Yeah, Woody's been posted on Instagram literally where he's at, chilling. Woody doesn't seem to be scared at all for his safety. The judge just incriminated himself. He didn't notify all parties of this ex parte communication, which is why defense brought it up in court. In fact, wasn't the judge angry the defense attorney knew about this? Exactly. Pretending he was ever going to notify the defense is his attempt at revising history. Well, I think he's just trying to cover his ass to show that it was proper to the other judge. Dude, I think this trial's going to continue. Not even trolling. Whenever this judge looks at this recusal and looks at the transcript, apparently the transcript, Woody never admits to killing Donovan Thomas. What he's saying. So that's confusing because they say it's only about his immunity deal. That's like giving the money back if you're getting caught robbing the bank and declaring there's no crime. Oh man, that's so good. This whole thing seems fucking corrupt to me. I think the trial's going to continue. That's my honest opinion. I'll make another video about the transcript when it gets released. Love you guys. Peace.